Good morning, sir. Sir, good morning.
General sir, good morning.
Good morning, sir. Good morning, sir.
It's time to start now.
Yes, sir. 9:55 to 10 will be lighting of lamp, and 10 o'clock the sharp will start, sir.
Okay.
Good morning, sir.
Good morning. Good morning, sir.
Madam Rakhi, you just pull your laptop towards your side because you're only. That's good. That's better. Much better. You have been adjusting the angles, but I'm adjusting your picture.
Okay.
Okay.
Sanjeev? Sanjeev? Mr. Sanjeev?
Good morning, madam. I am General Rajinder. I am the director of the Material Law School, and we welcome you. Madam Pro Chancellor will just join. There was some problem. He'll just join. Sir, unmute, sir, unmute. हाँ ठीक है.
General Rajendra, am I audible?
Yes, yes, sir. Yes.
Morning,
Sir,
sir.
Professor Dr. Nishta Jaswal has joined. Madam, Lieutenant General V.K. Sharma, Aviation, is the Pro Chancellor of this university.
Madam, you have to
And-
unmute.
Professor, unmute, ma'am. Professor M.P. Kaushik is the Pro Vice Chancellor. Unmute, ma'am, unmute. उसको बताओ संजुम का है.
Okay, now fine.
May we start?
Yeah, please go ahead. We can start.
In the words of B.R. Ambedkar, democracy is not merely a form of government. It is primarily a mode of associated living, of conjoint communicated experiences. It is essentially an attitude of respect and reverence towards fellow men.
A very blissful morning to everyone present. I, Tejas Shukla,
And I, Divyanshi Sharma,
are here to welcome you all to virtual conference on replacement of 3 criminal laws of British era by Bharatiya laws will lead to decolonization and ushering reforms, in-depth analysis. It is our extreme privilege to have with us Lieutenant General V.K. Sharma, Ati Vishesh Seva Medal, Honorable Pro-Chancellor, Amity University, Madhya Pradesh, Professor Dr. Anil Vashisht, Pro-Vice Chancellor and Officiating Vice Chancellor, Professor Dr. M.P. Kaushik, Pro-Vice Chancellor Research, well-acclaimed chief guest, Professor Dr. Nishtha Jaswal, former Vice Chancellor, Himachal Pradesh National Law University, Shimla, and present Vice Chancellor, Dr. Bhimrao Ambedkar Law University, Jaipur, Rajasthan. Registrars, deans, directors, all HOIs, HODs, faculty members, along with participants and dearest audience. We feel immense pleasure to have you all as a part of this conference.
light symbolizes divinity, purity, wisdom, and knowledge. The manifestation of such positive aspects of life will surely help us move forward in our careers and personal life.
The sound is not there. Somebody can check.
Leaders become great not because of their power, but because of their ability to empower others. And our Honorable Pro Chancellor is a perfect example for the same. Lieutenant General V.K. Sharma, an alumnus of erstwhile King George School, Shimla. He did B.Tech from College of Military Engineering, Pune, M.Tech degree from Pune University, and MMS from Osmania University, all with first class and with honors. He joined the National Defense Academy and passed out as a permanent commissioned army officer from Indian Military Academy in 1972. He was granted the President's Commission in the Corps of Signals in the Indian Army. He served the Indian Army for almost 40 years and retired from the highest rank of Corps of Signals and the highest rank of Lieutenant General in the Army, which is a 3-star and flag rank of the Army. He participated in Operation Rakshak and Operation Vijay during the Kargil. He also headed military delegation to France, Germany, and USA. For his meritorious services, he was awarded Ati Vishish Seva Medal by Honorable President of India on January 26, 2011. Honorable Pro Chancellor Sir is an excellent academician too. Under his able guidance, Amity University has grown by leaps and bounds towards excellence and has been awarded as the best private university of Madhya Pradesh, first in the year 2014 and again in the year 2017. A visionary divine Pro-Chancellor with a golden heart. I would like to request you, sir, to kindly deliver opening remarks for the conference. Please, sir.
Thank you very much. To begin with, I extend a hearty welcome to Professor Dr. Nishtha Jaiswal, who is the Vice Chancellor of Bhimrao Ambedkar University at Jaipur, to all the dignitaries who are present online, and all the students who have joined through virtual mode, and of course to the convener and to the Director, Law School, General Rajinder Kumar, who was thought of a very apt topic, and the topic replacement or virtual national conference on replacement of 3 criminal laws of the British era by Bharatiya laws will lead to decolonization and ushering reforms and in-depth analysis. I think the topic is very apt and which needs to be discussed, and especially our youth needs to understand the implications of these laws and how it is going to decolonize us and set our minds free from the old laws which are of British era and of old vintage. As far as India is concerned, the legal system has been followed from time immemorial. As per our scriptures, Manu's laws were there from times of Mahabharata and from times of Ramayana. As per Manu's laws, the punishment meted out for an offense conducted by a higher caste or by an individual holding a high position, for the same offense, he was supposed to get a higher punishment as compared to the same offense having been committed by a lower caste or a lower level person in the hierarchy. The rational way that those who hold power and those who can make a difference in the lives of people, if they commit crime or if they go against the law, they deserve a more severe punishment, and there should be a greater deterrent for them as compared to lower, lesser mortals who do not make that much of effect in administration or in management and do not hold high power. So those were the laws, but I think there was a rationale, and in those times, those laws were relevant and the society functioned quite well under those times. Then came IPC Indian Penal Code, which was laws formulated by the British, taking into account their perceptions about India and how the Indians would behave and how they should be punished. IPC is of 1860, which is valid now even, but the new laws have been replaced. 3 laws. One is to replace the IPC 1860 and to be implemented this new law, which is to be replaced by Bharatiya Nyaya Sanhita, is to be implemented with effect from 1st of July 2024, which is a big change. The second is the Indian Evidence Act, which is of 1862 vintage. That has been replaced also by Bharatiya Sakshya Adhiniyam. Sakshya means something which is evident, which is visible. So this is going to replace the Indian Evidence Act of 1862, also with effect from 1st July 24, and the Criminal Procedure Code, CRPC, of 1892 vintage has also been, and which was also later amended in 1973, that has also been replaced by Bharatiya Nagarik Suraksha Adhiniyam 2023. So all these 3 laws come into force with effect from 1st July 2024. Now, the research articles revolve around the 3 criminal laws which have been passed by both houses, and the consent has also been given by the President of India. And the major changes and reasons for this need to be known by all of us. Briefly, firstly, the definition of terrorism has been amended. Now, the terrorism which is now defined as per the new laws is, it defines that any act which intends to hurt the integrity, sovereignty, and unity of the nation is supposed to be a terrorist act. So any act which is hurting the integrity, sovereignty, and unity. So that is terrorism. Similarly, sedition has been now also amended. The old act has been removed and new act which says the term sedition mentioned under section 124A of IPC has been repealed from the criminal system of India, but another provision for offense that hurts the sovereignty and integrity of the nation is intact in the new bill. So the sedition also, the definition has been amended. Another important term which has been introduced is about lynching. You know, today there are problems that mob lynching is happening, and then the mob behavior is quite, it does not take into account the individual choices. The mob decides to kill someone and the mob does the act. So even now the lynching, that is a murder by 5 or more people based on a certain identity, such as caste, language, personal belief, will result in a penalty of life imprisonment or even death. So lynching has been made more severe offense, and which has been replaced, that means article section 375, 376 of murder have been now replaced by section 66 to 69 of BSSS. And mob lynching, the bill includes murder or grievous hurt by 5 or more people based on any caste, religion, sex, punishable with a minimum of 7 years of imprisonment and maximum up to life imprisonment or even death. So lynching has been taken care of well and proper in this new act. Also, section 377 of the act, which earlier IPC, which talked about homosexuality, that has been omitted, and which states punishment for that has been removed. And the minimum age for adolescent crimes, which is from 7 to 18 years of adolescence, has been added. And community service is also been added as a punishment. The aim of punishment in legal system is not to make a person suffer that much as to ensure that he comes back as a refined person so that he can fit into the mainstream of the society after the punishment is over. So taking that into account for minor offenses, like somebody say jumping the red light or somebody just trying to insult someone or very minor offenses, the punishment of community service has been introduced. Any community service. That means he will clean the road or he will clean the utensils or in a religious place or whatever community service has to be done as given by the Honorable Court, that has been introduced now. Also, the life imprisonment now means imprisonment till the end of life by natural process. That means a person who has been awarded life punishment, he is expected to be in prison for a long time. Police has been given more powers in this. That the custody has now been extended up to 15 days. That means the police can keep a person under custody before a charge sheet is filed up to 15 days, which is quite some time and quite a deterrent for the public. That means the chap will remain inside the custody for 15 days, which is quite a bit. And so therefore police powers have been enhanced. And all the trials and inquiries, of course, now can also be conducted in electronic mode, that means in online mode, if the courts so desire. Also, if a person has stayed in prison for 1/3 of the punishment that is given, then it also has a provision for bail. If an accused has served 1/3 of the imprisonment period which is prescribed. Also, the electronic evidence has been given much relevance in terms of inquiry, giving oral evidence, etc. And mandatory forensic evidence for offences that have a punishment of 7 years or more. So all these new terms have been included. There's a lot of debate possible on all this. There's a lot of debate possible on the powers which have been enhanced for the police, on various laws which have been made, and these, of course, need to be debated, thought over by all people involved in law, and also those not involved in law, because they will also get affected. And then I think there should be a number of theses and PhDs which could be done on the repercussions of these laws and how they're going to affect the society and whether they're in line with what is happening in the country today through various processes and procedures. Most important in legal system is the implementation of the laws. So you may have 20 laws, but if you're not able to implement them properly, then their charisma or whatever force that they have, that is of no use if these are not implemented properly. And the implementation of the legal system has to be done by the executive. It is the executive who is to implement these laws. So that is something very important. Legislature, of course, has made the laws. And also the practicability of implementation is most important. I think so. These are some of the aspects which I thought which came to my mind. And there's a lot of scope for discussion on all this. And I'm sure during the next 2 days, many ideas will come out, and ideas which should be received by all of us. I would recommend that all students of law must attend this and take into account the ideas which emerge, and also the implementability aspect, and also what all, just criticizing is not enough. We should be able to recommend what precise changes should be made in which sections. So these laws, being new, have not been probably read in depth and analyzed, which is the job which we are seeking to do in these next 2 days. So I wish this national conference a great success. And I wish you all the very best, and all students must listen to the ideas coming from the experts and those who are going to speak and participate in this conference. So thank you very much. Wish you all the very best. Jai Hind.
Thank you, sir, for enlightening us with your valuable words. To be a leader, you must be willing to sacrifice your time, for it is rarely convenient to be a leader. Professor Dr. Nishtha Jaswal, former Vice Chancellor, Himachal Pradesh National Law University, Shimla, and present Vice Chancellor, Dr. Bhim Rao Ambedkar Law University, Jaipur, Rajasthan, stands as a towering figure in the realm of legal academia, revered for her profound expertise and remarkable achievements and steadfast commitment to justice and societal welfare. With a career spanning over 3 decades, Dr. Jaswal has carved a distinguished path, leaving an indelible mark on the fields of law, education, and administration. Graduating with honors as a recipient of Gold Medal in BA, she showcased her exceptional academic prowess and an insatiable thirst for excellence. Dr. Jaswal's academic odyssey continued to flourish as she pursued advanced degrees, including LLB, LLM, and culminating in a PhD, exploring the intricate domain of constitutional law, administrative law, human rights, and environment law. Throughout her scholarly pursuits, she exhibits a fervent passion for knowledge acquisition and a profound interest in addressing pertinent legal challenges. With an illustrious teaching tenure spanning over 33 years, Dr. Jaswal has imparted her wisdom to countless students, shaping the intellect of future legal luminaries. Her unwavering dedication to academia and research is underscored by her prolific publication record comprising 58 papers and 6 seminal books across diverse legal spheres. Beyond her scholarly endeavors, Dr. Jaswal has made significant contribution to the administrative landscape of her academic institutions. She has assumed various leadership roles, including chairperson of the Department of Law and Dean of Student Welfare at Punjab University, Chandigarh, earning widespread acclaim for her administrative prowess and commitment to student welfare. Dr. Jaswal's impact transcends academia as she actively engages in societal welfare initiatives and legal reforms. Her involvement in numerous committees and bodies, such as Chandigarh Commission for Protection of Child Rights and the State-Level Authorization Committee of Punjab, underscores her relentless pursuits of societal welfare and justice. Throughout her illustrious career, Dr. Jaswal has garnered numerous prestigious awards and honors, recognizing her outstanding contribution to the legal fraternity and academia. Notable accolades include the esteemed British Academy Visiting Professorship in 1992, the coveted Amity Academic Excellence Award in 2019, and the prestigious International Extraordinary Women Award in 2020. Dr. Nishtha Jaswal's extraordinary journey stands as a testament to her unwavering dedication, scholarly excellence, and relentless pursuits of justice. Her profound contribution to legal academia and societal welfare serve as a beacon of inspiration, leaving an enduring legacy in the annals of legal justice. We request you, ma'am, to enlighten us with your profound words. Please, ma'am.
Thank you, Beta. At the very outset, I'm really obliged towards Amity University for giving me chance to be one among you, even though virtually, and especially on a very, very critical and important topic. Lieutenant General V.K. Sharma ji, Major General Rajendra Kumar ji, Professor Kaushik ji, Professor Chauhan, faculty members, participants. Being a teacher, elders, in fact, always deliver sermons and always try to evaluate. My words of appreciation for son and daughter who are conducting this program. Very good oration, Beta. God bless you. I'll start with Suktam from Rig Veda. Ano Bhadra Kratvo Yantu Vishwata, which means Let noble thoughts come to me from all directions. I should be able to evaluate these laws with all humility and with a critical eye. At the same time, because these laws are going to affect us collectively, any commoner, any administrator, any judicial officer, any lawyer. So I'll also recite Sangathan Suktam from Rig Veda. Samaniva akuti samana ridyaniva samanamastu vomano yathava susahasati, which means collected be our mind, united be our purpose, harmonious be our feelings, in the same way in which this nature exists in togetherness. Lieutenant General V.K. Sharma, he referred to Manusmriti. I'm going to refer to Chanakya, Kautilya, who wrote Arthashastra. And he's well known as giving advice on all political issues, even in this Dandaniti. Beautiful words. Saten dharyate prithvi, saten tapte ravi, saten vati vayushcha, sarvam satte pratishtitam. In fact, if we just go by crux, literally means everything depends upon truth. Whether it's earth, whether it's sun, whether we talk about air, everything depends upon truth. A truth. This truth has, in fact, a living place when we talk about commission of crime, controlling of crime, preventing crime, and even when the crime has been committed and we need to punish the accused. For this issue of punishment, I'll refer to Bhagavad Gita, chapter 10, verse 38. Lord Krishna, he said, Dando damaytama asmi nitir asmi jigishtam monam cha eva asmi guhyanam jnanam jnanvatam aham, which means I'm just punishment amongst means of preventing lawlessness and proper conduct amongst those who seek victory, amongst secrets and silence. In the wise, I am their wisdom. I hope all of you can just understand that why I cited this. This is what Lord says, that we need wisdom when we talk about laws, when we talk about controlling lawlessness. The moment there is lawlessness, then it's not merely our duties that we must prevent it beforehand, but because we have to deal with humans. Human nature is such. And we are all full of all kinds of false egos. And in the greed, in the lust, in the egos, we commit something wrong. And there are degrees of wrongs which are, and a degree comes when what is affected? My life, my liberty, my property. Now, different names to these wrongs may be given, but ultimately, we have to think from the angle of the victim, from the angle of the society, name and honor of the country. And that is why, if we just open the pages of history, we'll find there was one kind or other form of Dandaniti. We very well know we were being governed by the old British era laws on criminal issues, which was IPC of 1860, Criminal Procedure Code of 1898, Evidence Act of 1872. And in fact, there was somewhere in our hearts, whether we were right, whether we were wrong, that why we have gained independence, still we are being governed by these laws. And we have always been thinking of Indianization of everything, Indianization, which suits our environment, our culture. And we may be right, we may be wrong, there may be different schools of thought, some may criticize, some may appreciate what is being done, new laws are there. And we are aware of the journey, that how the committee was constituted, where the NLU, Delhi's vice chancellor, professors, they were part of the committee, and secretly everything was done. And we are, in fact, at that stage where we appreciate Prime Minister Shri Narendra Modi ji, because he always claimed that these new laws, they are paradigm shift in India's criminal justice system. And he emphasized on certain very, very important issues. Same is true about the public statements made by Amit Shah ji, especially when the focus was on the terrorist activities. So we have now Bharatiya Nyaya Sanhita replacing Indian Penal Code. Bharatiya Nagrik Suraksha Sanhita replacing Criminal Procedure Code, and Bharatiya Sakshya Adhiniyam replacing Indian Evidence Act. And all of us are well aware that these are going to be enforced from 1st of July 2024. Before I dissect various provisions, in fact, what would be the success rate? Whether we would be at a better position, only time can tell. We cannot predict, but we must always have hope and expectation. The twin sisters, we must keep in our minds. If I just refer to IPC, IPC was subdivided into 26 chapters and 576 sections, while now this BNS has 19 chapters and 356 sections. The 20 new offenses have been added in this BNS. 19 provisions that existed in IPC have been deleted. In 33 offenses, punishment of imprisonment has been increased. In 83 offenses, the punishment of fine has been enhanced. In 23 offenses, the mandatory minimum punishment has been introduced. And in 6 offenses, the punishment of community service has been introduced. There are some major changes which have been introduced in this new BNS. Reorganization of offenses are made wherein similar provisions have been clubbed together. Definition of child is introduced. Transgender is included in the definition of gender. Electronic and digital records are included in the definition of document. The definition of movable property is widened to include property of every description. New chapter on offense against woman and child is introduced. New chapter on inchoate offenses like attempt, abetment, and conspiracy is introduced. New offenses like organized crime, terrorist act, petty organized crime, hit and run, mob lynching, hiring child to commit offense, sexual exploitation of women by deceitful means, snatching, abetment outside India, acts endangering the sovereignty, integrity, and unity of India. Publication of false or fake news, etc., have been introduced. Attempt to commit suicide is deleted. We are well aware how such controversy had always been before the Supreme Court. We cannot forget Gyan Kaur's case and the case which followed, that we never talked about right to die as a fundamental right under article right to life. Beggary has been introduced as a form of exploitation for traffic. We must appreciate. A reason being, I can share with you, I had to be a member of Chandigarh Commission for the Protection of Child Rights, and we tried our best that child beggars should not be there on the roundabouts in Chandigarh. But you know, every time it took different forms, and you can watch yourself. Go to the prominent places in your cities and you'll find they are not begging now. They are just walking with some balloons in their hands, some paper napkins in their hands. But the form changes, exploitation remains there only. But there will always a question mark, which I'll keep on reiterating after a few seconds, that let us see to what extent we are able to implement. In the, as Lieutenant General V.K. Sharma ji also told, in the definition of grievous hurt, the number of days has been reduced from 20 to 15. Community services provided as a punishment for theft of less than rupees 5,000, and community service has been included as a punishment for the first time for petty offenses. New offense of terrorism. This is new provision added. Changes in punishment in hit and run cases. Sedition made not punishable by omission of section 124A of IPC. Instead, treason is made punishable under new section 52 of BNS. Scope of offense of theft expanded to cover theft of intangible items like theft of data. Like we can take the example of credit card skimming, identity theft, theft of intangible assets, in view of expanded definition of movable property. Snatching has been made a new offense under section 304. Now we have to remember different sections. Earlier, we used to talk about 304 in different contexts. And some more changes which I can just revolutionary changes. Earlier, importing girls under the age of 21 years for illicit intercourse with another person was an offense. Now the revised section 141 of BNS, which corresponds to section 366B of Indian Penal Code, specifies that importing boys under the age of 18 years for illicit intercourse with another person will also be an offense. Now, this could have a positive impact because there has always been a struggle for equality. Gender neutral laws we always talk about. Introduction of organized crime and petty organized crime are organized in general, example sections 111 and 112. Punishment for non-treatment of victim in section 200 of BNS is given. Simply we talk about whoever being in charge of a hospital, public or private, whether run by the central government, state government, local body, or any other person, contravenes the provisions of section 397 of Bharatiya Nagarik Suraksha Sanhita 2023 shall be punished with imprisonment for a term which may extend to 1 year or fine or with both. On sexual offenses, the laws have become more stringent. Sexual intercourse by deceitful means or false promise to marry will be considered as crime under section 69 of BNS. And the punishment prescribed is simple or rigorous up to 10 years and fine. It's not and or, it's and fine. Immediately it comes to my mind that this issue had been lingering before the Supreme Court in matrimonial cases, and there are fluctuating opinions. One is that this is adultery, false promise there, you don't marry, liability is there. Another is in the present circumstances, one comes to know this is only live-in relationship and there is no scope of marriage. So we did not have any final decision on it, and it could not be at that juncture taken as a crime. Then punishment for rape has been enhanced from 7 years to 10 years as given in section 64 of BNS, which corresponds to section 376 of Indian Penal Code. Earlier, section 376 of IPC provided whoever commits rape shall be punished with imprisonment of either description. Now, section 64 says whoever commits rape shall be punished with rigorous imprisonment. This is specific and clear. Death penalty for gang rape of women below 18 years of age, as per section 70 of BNS, corresponds to section 376 DB of IPC. Additionally, a new law protecting the identities of sexual assault victims has been introduced, which we find in section 72. New chapter, that is chapter 5, governing offenses against women and children. I have already talked about it. Now, earlier, there were in fact 5 kinds of punishments under section 53 of IPC: death, imprisonment for life, imprisonment either simple or rigorous, forfeiture of property, fine. Now, section 4 of BNS, it adds one more, that is, we have already talked about community service. And in number of cases, like when the public servant violates legal obligation to refrain from conducting trade, here community service is there under section 202. And in case of defamation also, which carries a simple sentence of up to 2 years, in jail, a fine, both, or, now this is very important, or community service as per section 356, which corresponds to earlier section 499. Community service or 1 year imprisonment as a punishment in attempt to suicide to compel or restrain exercise of lawful power by a public servant. Some minor changes also we can refer, but worth appreciating. At 9 places, the archaic expression like lunatic, insane, and idiot have been done away with. Colonial remnants like British calendar, Queen, British India, Justice of the Peace have been deleted. In 44 places, Court of Justice has been replaced with court. Uniformity has been brought in use of expression child, as I have already talked about, and contemporary style of drafting has been used. Now, some statutory changes, then I come to this Bharatiya Nagrik Suraksha Sanhita, which replaces Criminal Procedure Code and 1973. And this Bharatiya Nagrik Suraksha Sanhita 2023. Now, here focus is on the use of technology during investigations and trials and provision for definite time frames for various legal procedures. And this is a very, the step which is in the right direction and which is worth appreciation. Now, some changes we can talk about, like expansion of the possible duration of police custody, Judicial officer may give police custody for a term not exceeding 15 days in the whole or in parts at any time during the initial 40 days or 60 days out of the maximum detention period of 60 days. Then there is a criticism on this discretionary registration of FIR. Now, this BNSS provides that on receipt of information relating to a cognizable offense punishable with imprisonment between 3 years and 7 years, the officer in charge of the police station may, with the prior permission of his senior officer, proceed to conduct a preliminary inquiry to ascertain whether there exists a prima facie case for proceeding in the matter within a period of 14 days. How can we forget the year 2012 when came Supreme Court directions in Lalita Kumari's case, and where mandated the police to record information of a cognizable offense as FIR and investigate the offense regardless of what the police felt about the credibility of the information. There's a total difference in the legislation. Let us wait and watch what happens when such matters appear before the Supreme Court. And we cannot forget one thing, that is, we have one grand norm in our country which is sovereign, that is the Constitution of India, and every law, its constitutionality can be checked, can be tested. Let us see what happens. Then it took years for the Supreme Court to talk about handcuffing as cruel, inhuman, barbarous. We cannot forget the decisions of like Prem Shankar Shukla's case of 1980, where Supreme Court, while issuing the guidelines, said handcuffing can be resorted to in a rarest of rare cases, and try to explain rarest of rare cases when the offender is a hardened criminal and there is no other alternative to prevent his escape. Then you use, even in fact, Justice Krishna Iyer went to the extent of saying that handcuffing, this can be there in white collar crimes. But here, now again, the present jurisprudence written in Sunil Batra, two Sunil Batra cases, there is a lot of change. Section 43, subsection 3 of BNSS talks about and says, gives this discretionary power to the police to handcuff accused persons for serious offenses, including but not limited to rape, acid attack, murder, sexual offenses against children, drug-related crimes, and so on and so on. What is worth appreciating that this, as I have already talked about, focuses on use of technology, forensic science. This BNSS mandates forensic investigation for offenses punishable with 7 years of imprisonment or more. Then even this talks about the expanding the scope of biometrics and provides that any person can be ordered by the magistrate to give specimen signatures, finger impressions, handwriting, provide samples in connection with an investigation or proceeding, even if he or she is not an accused person. Again, I'll say constitutionality. We have Article 20, Clause 3. And we have traveled from Kati Kalu, MP Sharma, and coming to the finer scope that what should be there. The person against whom some charges are there could not refuse, but Supreme Court has in fact declared right to privacy also as a fundamental right, especially after Puttaswamy case. Again, we'll have to wait and watch. And another very important is zero FIRs. And this BNS provides for zero FIR and states that an information relating to the commission of a cognizable offense, irrespective of the area where the offense is committed, that is section 173, may be given orally or by electronic communication to an officer in charge of a police station. And many other changes are there. What is again worth appreciating, the issue of bail, because in some cases now Supreme Court, even in 2023, Supreme Court has talked about right to default bail. But again, that changed provision is there, not as a bail, not as a matter of right. Again, I'll say the same thing. Let us wait and watch. What is worth appreciation that from, I think, late 70s, early 80s, we had been talking about right to speedy justice. Right? We may talk about Zain Ara Khatun and so many cases. And even we talk about right to access to justice as a fundamental right. A step is towards this. Anil Roy's case of 2001, where in fact the Supreme Court laid down guidelines that within how much time the case is to be decided, but there was no as such implementation. Now the legislation is there, worth appreciating when it says, for offenses punishable for 3 years or more, but less than 7 years, the officer in charge may, with the prior permission of the Deputy Superintendent of Police, proceed to conduct a preliminary inquiry within 14 days to ascertain if there exists a prima facie case and proceed with the investigation where there exists one. The police are now under an obligation to inform the victim or informant of the progress of the investigation, including by electronic communication within 90 days. Further investigation shall be completed within 90 days, which may be extended, but safeguard is there, that is with the permission of the court. And further, we find when in a case instituted, the accused appears or is brought before the magistrate and it appears to the magistrate that the offense is triable exclusively by the Court of Sessions, he shall commit the case within a period of 90 days from the date of taking cognizance, and such period may be extended for a period not exceeding 180 days for reason to be recorded in writing. In fact, we are following the principles of natural justice also. Whatever we say, wherever action is there, order, decision, provision has to be reasoned one. And further it talks about supply of police report and documents where the proceeding has been instituted on a police report. The magistrate within 14 days from the date of production or appearance of the accused supply to the accused and the victim a copy of police report and the documents. Regarding discharge of accused, the accused may prefer an application for discharge within 60 days from the date of supply of copies of documents, and framing of charges will be within 30 days from the date of first hearing on charge. After hearing arguments, the judge shall give a judgment within 30 days from the date of completion of arguments, which may be extended up to 45 days for reasons to be recorded in writing. And in every inquiry or a trial, now this is the disease of adjournments. The proceedings will continue daily until all the witnesses in attendance have been examined, unless the court adjourns. Not more than 2 adjournments will be granted. So this is worth appreciating. And even regarding the proclaimed offender, the definition has been expanded. Now, BNSS has altered this provision which was there in CRPC and provides that anyone accused of an offense with more than 10 years imprisonment could be declared a proclaimed offender. Regarding trial in absentia for proclaimed offenders, also clear provision is there. And there's a clarity on reporting obligation also. Now, this law makes it clear that no reporting to authorities is required in cases of corruption and other economic offenses unless they form part of organized crime. Now, this is, in fact, we are just blocking transparency for the purposes of controlling those evils which are eating up the society and which are the reasons why we are not able to deal with or control the crime rate. So these are all worth appreciating. Coming to the Bharatiya Sakshya Adhiniyam 2023, which replaced Indian Evidence Act 1872. This Bharatiya Sakshya Adhiniyam consists of 170 sections as compared to 167 sections which were in Indian Evidence Act. Definition of evidence has been changed. It includes now statements given electronically as well as documents. Regarding confession, provisions are almost the same, only there is a rearrangement of the provisions. And if I refer to expert opinion under section 45 of Indian Evidence Act, which stands modified to specify that the opinion of the examiner of electronic evidence as per section 79A of the IT Act shall be a relevant fact for information stored digitally. Now, this is section 39. Now, in fact, this Bharatiya Sakshya Adhiniyam also recognizes digital and electronic records as primary evidence under section 57. Section 58 talks about secondary evidence. It includes additional categories such as oral admissions, written submissions, evidence of a person who has examined a document, the original of which consists of numerous accounts or other documents which cannot conveniently be examined in court. Now, section 61 also talks about these digital and electronic records which have the legal effects. 63 talks about types of digital and electronic records. And new section 61 I have already talked about. Then the proof of certain documents from section 78 Indian Evidence Act, this has been deleted, and certain provisions relating to certain presumptions under section 81 have also been deleted. Even section 82 deleted. Section 113, which talked about conclusive proof regarding the cessation of certain territories to native states, has also been removed. Section 166 of Indian Evidence Act have also been removed.
Hello.
Now,
Speakers.
after
Okay.
just referring to different changes, inclusion, addition, subtraction, removal, deletion of different provisions, now we need to peruse the minute nuances of these provisions. One school of thought, in fact, criticizes that why we needed a new laws. We could have easily amended, and it is always easy to make amendments. Clear criticism is like on the sections 24 to 30 of Indian Evidence Act, which dealt with confessions, that nothing has been done except changing the numbering of the sections. Now, regarding denial of bail, this has also been criticized. As I already talked about, then power to use handcuffs has also been criticized. Then issue, because nowadays we talk about right to privacy, so data collection has increased, will increase, and the issue of data privacy has also been talked about. I can just refer to one decision in the year 2005, District Registrar versus Collector Canara Bank. Now here in this case, in fact, Supreme Court very clearly, because talking about rule of law, talking about privacy issues, talking about fairness, because the moment we talk about our right to life, which has been guaranteed under Article 21 of the Constitution, it says that no person shall be deprived of his life or a personal liberty except according to procedure established by law. And we are well aware that now this procedure established by law is in the same form in which American due process clauses exist. That every procedure for depriving you of your life or personal liberty has to be fair, just, and reasonable. Similarly, the law, the substantive law, has also to be fair, just, and reasonable. Like in this particular case, Supreme Court had said that when the magistrate directs for seizure of some documents, and we know when you have the warrant for search and seizure, what happens? But Supreme Court said that every person has a dignity, every person has a right to privacy. You adopt this process only when there is no other alternative and investigation cannot take place without that. But now we have the legislation only. Now, one criticism is there is ambiguity in provision relating to public order. And now we talk about community service, because now we are in the era where we not only talk about the accused, but also victim. And our concentration is on a reform. And in fact, we are raising our voice at the loudest pitch that it's not that we have to punish, it's we have to do justice. So one punishment is in the form of community service. But what is community service? This has not been defined. And even though we talk about gender neutrality, but how, to what extent? Again, that means we will be depending upon the guidelines which will come from the apex court when such issues arise. And in fact, this is how it is. But I would say one thing very, very clearly: we may have plethora of laws, but ultimately, when the issue is the relationship between two human beings, no doubt, when the issue of law and order is there, commission of crime is there, one party is the state. It is state's obligation. But state cannot control your mind. State may put you in chains. State may punish you. But can your mind be changed? Can anybody read your mind? We are not going into the root cause for the commission of any crime. So let us see ultimately what happens. Most of you are aware, but I'll again say I'm a poet by heart, so I'll conclude with my own poem on the issue. इतिहास गवाह है, इतिहास गवाह है, अपराध हर समाज में जन्मता है. इतिहास गवाह है, अपराध हर समाज में जन्मता है. अपराध दंड को प्रणालियों का समय अनुसार केवल रूप ही बदलता है. अपराध दंड को प्रणालियों का समय अनुसार केवल रूप ही बदलता है. दंड नीति के सिद्धांतों की चर्चा कई रंगों में, दंड नीति के सिद्धांतों की चर्चा कई रंगों में हुई. कानून बदलने की कोशिश कई अंगों में हुई. कभी जुटे थे अपराधी पर करुणा अमृत वर्षित करने को. I can refer to Article 20. So many things were there. कभी जुटे थे अपराधी पर करुणा अमृत वर्षित करने को, मगर न चली चाल दंड नियम सरल करने को. मगर न चली चाल दंड नियम सरल करने को. जैसे जैसे तकनीकियों का दौर आगे बढ़ा, जैसे जैसे तकनीकियों का दौर आगे बढ़ा, वैसे वैसे नए अपराधों का रंग समाज पे चढ़ा. वैसे वैसे नए अपराधों का रंग समाज पे चढ़ा. एक टीस सी उठती रहती थी हृदय के किसी कोने में. एक टीस सी उठती रहती थी हृदय के किसी कोने में. शहादत से मिली आजादी. शहादत से मिली आजादी दुख है अंग्रेजी कानूनों के होने में। वो बेला भी आई जब अपने दंड कानून पारित हुए। वो बेला भी आई जब अपने दंड कानून पारित हुए। सोचा दंड नीति से नहीं, न्याय नीति से प्रेरित हुए। सोचा दंड नीति से नहीं, न्याय नीति से प्रेरित हुए। विशेषज्ञ विच्छेदन और अध्ययन से, विशेषज्ञ विच्छेदन मीन्स डायसेक्शन, विशेषज्ञ विच्छेदन और अध्ययन से सत्य से हुआ सामना। सर्वोच्च न्यायालय के कई दिशा निर्देशों को छोड़ा हमने थामना। फाइनली आई प्रे टू गॉड, एरब बहुत आसान है आलोचना का आंचल थामना। एरब बहुत आसान है आलोचना का आंचल थामना। जरूरत है घूंघट हटाए और उद्देश्य को जानना। जरूरत है घूंघट उठाएं और है उद्देश्य को जानना। सर्वे भवन्तु सुखिनः।
We thank Professor Dr. Nishtha Jaswal very much for such a informative talk, which kept all of us spellbound and mesmerized. We heard a lot about you, ma'am, from the people, my friends are there in Shimla, where I was posted long back. So we heard a lot about your expertise in law, and some of my colleagues who are in the army, in the judge advocate general department, who happen to be Jaswal only from Shimla. So we heard a lot about you. Then we thought we will call you, and we invite you to grace
Thank you, Ji.
such an important event. So we thank you very much, ma'am, for sparing your valuable time to grace the inaugural session of this conference. Thank you very much.
Thank you, sir. Thank you.
Thank you, ma'am, for your wisdomful words. Thank you, sir. You gain strength, courage, and confidence by every experience in which you really stop to look fear in the face. In our journey through life, we encounter numerous challenges and obstacles that may evoke for fear and uncertainty. Yet, it is precisely in those moments of fear that we have the opportunity to cultivate. With this, we wish all the participants best of luck and hope this exciting experience will not only broaden everyone's horizons of understanding, but will also be a lingering taste of togetherness, which will surely find a beneficial niche. I request all the participants to join their respective panel sessions. Good luck to all. Have an amazing and fruitful day. Thank you.
Thank you, Ji.
Thank you, ma'am.
Thank you, ma'am.